Hello students and welcome to the next session of the company law. In the last previous session, we have discussed about the debenture, the concept of debenture given under section 2 subsection 30, types of debentures. We try to understand the difference between debenture and shares, and then provisions relating to the issue of debentures given under section 71 of the Companies Act 2013. Now we'll proceed further and we'll try to now understand the provisions relating to the charge. So let's get started. Charge. So what is meant by charge? The charge is defined under section 2 subsection 16 of the Act, which says that it is an interest or lien created on the property or assets of a company or any of its undertakings or both as security and includes a mortgage. Okay, so if we read this definition very carefully, we will understand there are few aspects, like it is an interest or lien. It is a kind of interest or lien which is created on what? Which is created on property or assets of the company, or any of its undertakings, or both as security and includes mortgage. So these are some of the aspects of the definition of charge what we are going to study. So the charge, let's first try to understand what is charge all about. So whenever a company obtains a kind of term loan or working capital from the financial institutions or banks for that matter, so company may have to offer its property or assets as a security. So in that case, company will have to register or create a charge. Company will have to create a charge on that particular part of the property or assets in favor of that lender. So lender in this case is the financial institution or the bank who is providing a loan to the company. So in other words, what we can say, the creation of charge is necessary in case of the secured borrowings availed by the company. So in the last lecture we have talked about the secured debentures also. So even where the secured debentures are issued, a charge on the specific movable or immovable property needs to be created in favor of the debenture trustee. Okay, so these are the provisions. So charge is nothing but a kind of security which can be created on the assets or property of the company while taking a loan. So when the company is borrowing funds from financial institution or the bank for that matter, the lender will ask the company to create the charge, and the lender will become the charge holder for that matter. So where to register a charge? The charge is to be registered with register of companies. It becomes a kind of information available in the public domain, which can be used by the lender, okay, anytime. So apparently after registration, the company is precluded from offering the same assets again to borrow the funds fraudulently from a further lender or different lender for that matter. So where exactly you can go and find out the details about the charge, one can go on the website of the Ministry of Corporate Affairs, click on the register of the charge and put the information of the company. One can easily retrieve the details whether the company has created any charge with the in favor of any particular lender or not. So company cannot obtain or borrow the funds on the similar charge for that matter. So lender, while giving any kind of money or lending any kind of money, will have to first look into all these details, and it is always advisable to look into all these details before creating the charge. Now we will try to understand types of the charge. We will try to understand types of charge. There are basically two important types of charge. One is fixed charge and second one is floating charge. Okay, so there are two types of charge, fixed charge and floating charge. So what is exactly meant by the fixed charge? A fixed charge is a charge which attaches specific assets of the borrowing company. So which are those specific assets? So these assets are of the kind of permanent nature, fixed assets, okay, of the company. So you may say like a land and buildings, office premises, plant and machinery installed by the company in the manufacturing setup, and which can be identified at the time of creation of the charge. Okay, so fixed charge is created on the fixed assets of the company. It is created on fixed assets of the company. Fixed assets of the company. So when a charge is created on these fixed assets of the company, the charge remains fixed and the borrowing company is not permitted to sell. So for example, we can say, I think I need to give the example. For example, you can say land and building, then the machinery is treated as fixed assets, office premises, etc. Because it is fixed in nature, one can easily identify these assets at the time of creation of the charge. So when a charge is created on these particular assets, the charge remains fixed and the borrowing company will not be in a position to sell these particular assets. Though it may happen, okay, in creation of the charge, it is not like that, okay, the borrowing company cannot use these assets. Borrowing company can very well use these assets. Charge is different from the mortgage, and we are going to understand the difference between charge and mortgage as well. So for a time being, try to understand, once the charge is created, it does not mean that company cannot use those assets. Company's assets will be, the possession of the assets will be very well with the company, only that right will be given to the lender, okay, that the sale cannot happen, okay, on the property which has been on which the charge has been created. So fixed charge can be created by the way of mortgage. So the company, the borrowing or the lender for that matter, will first get the mortgage deed registered, then deposit of title deeds. It can be created by way of mortgage. It can be created by way of mortgage, so that there can be deposit of title deeds, okay, the type of the mortgage. So assets under this particular fixed charge can be sold only with the permission of the charge holder. That is very important. So if any assets, the company, borrowing company would like to sell in the future, it can only do so with the permission after taking prior permission from the charge holder. So if a fixed charge is vacated when the money borrowed against is paid in full, along with the interest due thereon, then it can be properly satisfied. We will talk about that little later. So this is all about the fixed charge. What is meant by floating charge? It is created on the assets which are of fluctuating nature. So floating charge, it is created on assets which are of fluctuating nature. So for example, if I want to give you example, you can say like raw material or stocking trades. These are all the fluctuating nature assets. Now these assets, how this charge can be created by way of hypothecation or lien. It can be created hypothecation or lien. So it can be created by the deed of hypothecation or lien. So the assets under the floating charge keep on changing. Try to understand, because this raw material is not going to be the same forever. It will keep on changing as and when the raw material will be converted into the finished goods. Because the borrowing company is permitted to use them for producing the final goods or the finished goods for that particular matter. So which is the subject matter of the charge? This raw material or stocking trade shall be used by the company to manufacture the finished goods. So it may not be the same always. So company basically try to understand, companies to free to use all these floating or all these particular assets which on which the charge has been created. Now there is a concept called as crystallization of the floating charge, which we'll talk little later. So we can say that the floating charge is the present security which covers in its fold all such assets which are mentioned under the hypothecation deed. So hypothecation deed is basically created on the movable assets, and it can be the mortgage is created on the immovable assets. So these pointers are very important. It is created on the fixed asset. It is created on the assets which are of fluctuating nature. It can be land or building, machinery, office premises, raw material or stock in trade. So these pointers are important for you to understand. Now we'll try to understand a concept called as crystallization of the floating charge. Crystallization of the floating charge. Crystallization of floating charge. So floating charge is basically remains dormant until it gets crystallized or fixed. So on crystallization, the security becomes fixed and can be available for the realization so that borrowed money can be repaid. Now when the crystallization of the floating charge may happen? So it may occur when the terms or conditions on the floating charge are violated by the company. So you can say that it may occur first. You need to write down, okay, on crystallization what will happen, then we can talk about the other points. On crystallization, the assets under floating charge becomes fixed. So that is the process. It may occur when terms and conditions of floating charge are violated. Or so you can say that this is point number A. We can mark this as point number A. We can mark this as point number B. This is my point number A, point number B. The company ceases to continue its business, or point number C, the company goes into liquidation or point number D, the creditors enforce the security covered by floating charge. So this may happen in case of, let's say, debenture holders. Okay, so crystallization is the process where assets under the floating charge will become the fix. Why it will become the fix? Because the creditors, for that matter, can realize their payment. Okay, so repayment can be done. So if there are various situations which may occur, then only this process will happen. So it becomes fixed in this particular matter. When it will happen? Okay, it may occur in all these four situations. Either of this situation, when the terms are violated, okay, terms and conditions are violated for the floating charge, company ceases to carry on the business, okay, continue its business. Company goes into liquidation when a company has gone for the liquidation, okay, under insolvency and bankruptcy court, and the creditors enforce the security. Okay, if the payment is not paid, okay, to the debenture holders, and if those are the secured debentures, then Creditors, because they are the creditors for the company. So the secured debenture holders may enforce the security covered under the floating charge because they want to get the payment done. So this is the process of the crystallization of floating charge. So far we have understood the definition of the charge and then its types, and then we are going to move on to understand something about the provisions of the charge. So provisions of the charge are given from section number 77 to 87. Section number 77 to 87. Provisions of the charge. Provisions of charge are given from section number 77 to 87. Okay, we may not have to go into the detail of the provisions of the charge. In nutshell, okay, we will try to understand what is exactly what the provisions all about. So provision starts with when a company obtains a loan, okay, borrowing, or any lender lends the money to the borrowing company. So company has to first create the charge on the assets. Okay, so that procedure is called as registration of the charge. So company has to, okay, it is a duty of the company, it is a prima facie duty of the company, okay, it shall be duty of the company, that is the registration of the charge. So first process is always registration of charge. Now this registration, okay, has to be done by the company, and if company fails to do so, okay, if company fails to do so, then that registration may happen, or the charge holder may go and create the charge. So even the charge holder is also authorized to register a charge. So this is my step number 1. So my step number 1 is registration of the charge, and after that, okay, if there is any kind of modification happening in the relating to the terms and conditions of the charge, then those can be modified further, and those particular provisions, the relating to the modification, should be also intimated to the register of companies. So my step number 1 is registration of the charge, and if any kind of modification happening, okay, in case of modification, in case of modification, then modification of the charge, modification of charge. Next, step number 3 is after making the repayment and the interest due thereon, the company will have to satisfy the charge, and that procedure is called as satisfaction of the charge. Satisfaction of charge. Okay, so first step is always registration of the charge, then modification of the charge in case of modification, and then third one is the satisfaction of the charge. So these are the provisions which are given under section from section 77 to 87, how that registration will happen, how the modification will be done, and satisfaction can be done, okay, with the register of companies. So till the time the charges are satisfied after making the repayment, and if the charges are not satisfied by the borrowing company, okay, those will be considered as the live charges on the, and it will be available, those will be reflected on the domain of the MCA website, okay, because those will be the live charges, and one can review it and one can consider it as the live charge till the time it has been properly satisfied. So these are the provisions relating to the charges. So far we have studied the definition of the charge, then types of charge, crystallization of floating charge, and provisions of the charge. Just make a note of all these points. Then types of the charges we have studied. So make a note of all these particular points. Then we have studied about the crystallization of the charge, floating charge, how it will become the fixed for the realization. And step 3, provisions of the charge. So here we have completed the topic relating to the charge. We understood the types of the charges, floating and fixed. We have understood the crystallization procedure and the provisions relating to the charge in nutshell. Now we are going to move on to the very important topic. The next topic would be membership in the company. Membership in the company. So where the definition of member is given. So definition is given under section 2 subsection 55 of the Act. So we says that a member in relation to a company means a member in relation to a company means the first is the subscribers. So first the subscribers, second who agrees in writing to become a member, who agrees in writing to become a member. And third, every person holding shares of a company in the records of depository. Okay, so these three criteria, either of these three criteria should be made. So a member is nothing but a shareholder of a company. So member is a person. So what is the slight difference between the shareholder and the member? So shareholder can be treated as the member once his name will be entered into the register of members. So how a person can become a member? So member in relation to a company means the subscribers. So when a company is going to be incorporated, if it is newly incorporated company, then the subscribers whose details are given in the subscription clause of the company, and they shall be deemed to be have agreed to become the member, and after its registration incorporation, their names will be entered into the register of members of the company. So they will be deemed to be the members of the company because of the subscription. So every other person after that who agrees in writing to become the member of the company, and after that whose names will be mentioned or enter in the register of members, can become the member of the company subsequently. And third, okay, if the company is listed on the stock exchange and whose details, whose names are enter as a beneficial owner in the records of the depository, then they shall be deemed to be the member of that particular company. So this is a definition which is given under the section 2 subsection 55 of the act. Now we'll try to understand who can become the member and who cannot become the member. So let's try to understand who can become the member. So with the definition we can make out few points who can become the member and who cannot become the member. So first, company can become member of another company limited liability partnership foreigners can become the member. Either it may be body corporate or individual. Minor can become the member through its guardian, natural guardian or legal guardian. Trade union can also become a member in the company. So these are the persons who can become the member, okay, in the company. Who cannot become the member in the company? Who may not become a member? So first we have tried to understand who can become a member. Now we'll try to understand who cannot become a member. partnership firm cannot become a member. Pawnee. So when there is a clause, there is a contract of pledge. So Pawnee just because, or you can say official receiver. Okay. So when there is the partnership firm, because partnership firm is not treated as the separate legal entity in the eyes of law. Pawnee, when there is a contract of pledge between the company and the Pawnee, company being the pledger, Pawner cannot become the member just because the Pawnee is holding the share certificates by which it cannot become a member. Official receiver, in case of the insolvency or liquidation proceeding, official liquidator cannot become a member. So we have seen the list. A company can become a member in another company. There is no harm, because first and second point, they are the these particular entities are the separate legal entities in the eyes of law, and that is the reason these entities can very well become the members in the company. Foreigners, either individual or body corporate. Minor, though minor cannot enter into a contract, is not competent to enter into a contract, but minor can become a member provided he has executed the deed through his guardian and trade union. Now we'll try to understand modes of becoming the member. Modes of becoming member. So how one can become a member? First is by subscription. To MOA. Second, by an application and allotment. By transfer of shares. By transmission of shares. Or by holding shares as beneficial owner in the records of depository. Okay, so one can become a member by subscribing to the memorandum of association. All these points we have discussed in detail, in our earlier sessions. So by subscribing to the memorandum of association, one can very well become the member. So if he has not subscribed and later on he wants to become the member, so whenever a company will come up with the new issue, he can subscribe to the securities by making an application, and after allotment of the securities in his name, he can become a member. He can even purchase the securities from the existing shareholders, and that procedure is called as transfer of shares. So we have already discussed about this particular point as well in detail. By executing a deed of instrument, transfer instrument as per SH4 form, he can become a member. And if the shareholder is deceased, his shares will be transmitted to the legal heir of the deceased shareholder. So by transmission, the legal heir can also come on the record of the members, and his name will be entered into the register of members. Or if this particular point, last point we have already discussed in the definition, if anybody is holding the shares as a beneficial owner in the records of the depository, then also he will be treated as a member. Okay, so these are modes of becoming the member in the company. How one can okay cease to be a member. So cessation of the membership. Cessation of membership. How can one cease to be a member of the company? So again, there are various ways. A person may cease to be a member of the company if, in case he transfers. If he transfers his shares to another person. Okay, if he transfers his shares to another person. If his shares are forfeited. If he dies, if he becomes insolvent, if his preference shares are redeemed, if his preference shares are redeemed, if he rescinds, the contract of membership on ground of fraud or misrepresentation. If company is wound up. If company is wound up. So these are some of the grounds, okay, for the cessation of membership. So let's assume that after becoming the member, if he transfers his shares to the another person, so he will be ceased to be the member from the date of the transfer. Of course, his details should be mentioned. Details should be altered to that effect in the register of members. If his shares are forfeited, so forfeiture of the shares is the procedure. Okay, it means taking back the shares by the company from the shareholder. So why this forfeiture can happen? If the shareholder makes a kind of default in the payment of calls on shares, then company will have option to forfeit the shares of the shareholder. But to be a valid forfeiture, company will have to follow a certain process, because that right has to be given under the Articles of Association. The board resolution has to be passed for the forfeiture of shares. Proper notice should be served to the concerned shareholder, and it should be done with the bona fide intention and for the benefit of the company. So this is what all about the forfeiture of shares. So once the shares are taken back by the company, that procedure is called as forfeiture. So if the shares are forfeited, he will be ceased to be the member in the records of the company. If that person dies after the death of the member, the shares will be transmitted to his legal heir, and that is the reason his name will be removed from the register of members. If he becomes adjudged insolvent by the court, by the competent court, if he has been declared as the adjudged insolvent, then he will be ceased to be the member in the records of the company. If the preference shares have been issued and the preference shares are redeemed, then after redemption of the preference shares, a member will be ceased to be the member in the records of the company. If we have already discussed this second last point, when we have understood the prospectus, if any kind of misstatement in the prospectus has been committed, or if any false information has been provided to the proposed investors of the company, proposed shareholders of the company, and subsequently if the shareholder found that the information was false, and on the basis of the false information provided in the prospectus they had invested the funds, so those shareholders will have right to rescind that particular contract with the company, and after they rescind the contract, or after they decide to cancel the contract on the basis of the fraud or misrepresentation, then there will be cessation of the membership, and the shareholders' names will be removed from the register of members. And of course, if the company goes for the winding up, then definitely company will have to remove the names of the members, because company will not be in the existence at all, and the cessation of the membership will automatically happen. So these are the ways by which company will have to cease the members will be ceased to be the member in the company. The last topic we can complete for the today's session is the register of register of members. So we can say that register of members. The provisions are given under section 88 of the Act, which lays down that every company shall keep and maintain shall keep and maintain following registers. So which type of registers company will have to keep and maintain? First one is register of members, register of debenture holders, and third one is register of any other security holders. So provision given under section 88 of the Act says that a company will have to keep and maintain certain registers. These registers have to be maintained at the register office of the company. If company wants to maintain this register at some other place, then for that matter proper resolutions should be passed, and then company can be authorized to keep those registered at certain other place. So every company shall keep and maintain the register of members. So register of members will contain the details of all shareholders of the company, whatever the transfers will happen, transmission will happen, every possible details of the transmission should be properly entered from time to time. So all the details whichever as mentioned on the share certificate should be properly matched with the register of members. Register of debenture holders. Okay, if the company has issued the debentures and any other securities for that matter. So these registers are required to be maintained by the company. So students, we have completed topics relating to members. Few topics are remaining which we may complete in the next session. So we may just make a note of all these points. Who may become a member? One more part we can complete over here. Various rights of members. So which are the various rights of the members? Right to receive financial statements, right to receive notice of general meetings, right to attend, right to attend general meetings and exercise voting rights, right to transfer shares, right to receive dividend when declared, right to appoint directors and auditors, right to have right or bonus shares, right to share surplus profits in case of winding up, right to file class action suit before a tribunal. Okay, so these are some of the rights available once a person becomes the members. So he is entitled for the financial statements of the company. He is entitled for the notice of to attend the general meeting of the company, so he should receive the notice of the general meeting. After receipt of the general meeting notice, he can attend the meeting and exercise his voting rights. He can even appoint a proxy if he is not able to attend the meeting. He can have the right to transfer his shares. Transferability of the shares is one of the very important right which is available with the is one of the very important feature of the company form of business. He can have right to receive dividend when declared, because equity shareholder, okay, he cannot exercise this particular right. Whenever a company will declare the dividend and company is a profitable entity, then definitely he will have the right to share the dividend as well. Right to appoint directors, one of the very important rights, that company's operations will be taken care by, carried out by the directors of the company. The statutory auditors can be appointed by the shareholders during the general meeting. If he is the equity shareholder, then he can have the right to participate in the issue of right shares, or he can receive the bonus shares as well. He can have right to share the surplus profits in case of the winding up. So whatever the surplus profit will be there can be shared with the shareholder members of the company, and he can file an action suit, class action suit before the tribunal. So if any problem will occur, so that is the right given, like in case of the misstatement in prospectus, we have seen if any false information is given, the public at large may be deceived, so they will be affected and they will have the similar cause of action. So class action suit can be filed. One representative can go ahead and file a class action suit on behalf of public at large. So these are the rights available to the members. So you can just make a note of all these rights. Right to receive financial statements, right to receive notice of the general meetings, attend general meetings, he can exercise voting rights, transfer of shares, he can receive the dividend when declared, right to appoint directors or auditors as well. Right to have bonus or right shares, surplus profit, or class action suit can be filed by the shareholders. So here we have completed the topic relating to the members of the company. So we have seen under the members of the company the definition, who may or may not become the members, modes of becoming members, cessation of membership, what will happen about the register of members, and the rights of the members. So all these are very important questions from exam point of view. Along with that, we have also completed the topic relating to the charges, types of charges, crystallization of floating charge, and provisions relating to the charges. I hope you have understood these provisions very well. Do watch this video, read the notes carefully. We will meet very soon with the new topic. Till then, goodbye.